In this section, we will discuss the court system of Texas. In the court systems, not just Texas, but in all court systems, there are certain, I guess, procedures or things to think about when you are trying to make the proper judicial decision. And for courts who are supposed to be, of course, blind to anything besides the law, here's some different things that they must consider. They must have a passive appearance. Courts must have a passive appearance. They must not seek out cases. Okay, they don't pursue cases. Cases come to them. If there is a dispute or an arrest, they come to the court. The court does not go looking for cases to fill their docket. There are strict rules of access in the court decision-making process. Individuals and entities must have standing, meaning something must have happened to them in the geographic area that the court presides over. There are no hypotheticals in court. You can't come to go before a court and say, well, I just want to know if I did this or if this happened, how would you rule? They don't do that. It must be a real case with real people or entities, businesses, or whatever, but in order to have standing. So it must be a real case, no hypotheticals. There are strict procedural rules with regard to all courts. When and how facts and evidence may be presented. It can't be done willy-nilly. People just can't, jump up and start proclaiming their innocence or start, lobbing accusations at people in the courtroom environment. There are very strict rules where, one side goes first, then the other side can cross-examine a witness, and there's certain rules as to the kind of evidence that can be put forth in a trial. So there are strict procedural rules, or rules as to how things are done. Also, stare decisis is a very important concept. Stare decisis means the decision shall stand. That means that basically courts must rely in a great part on precedent when making decisions. Precedent means the first person or the first time something has happened. You set the precedent. So if a new type of case comes before, let's say, usually it's a Supreme Court. If a new type of case or a new it's hard to explain, a new not new type of case, but a new type of interpretation of the law or something like that comes before a court and the court rules on it, then all future court decisions by other courts must follow that ruling unless that ruling is overturned. So when it comes to like definitions of free speech or freedom of religion, what constitutes freedom of religion, what constitutes freedom of speech, when the Supreme Court makes those decisions, then those are precedents. And then stare decisis, which means the decision shall stand, means that all other courts in America must abide by that decision and must follow it. And appearance of objectivity. This is maybe the most important concept in court decision making. The court must appear to make objective decisions based on facts and not decisions based on politics or personal preference or biases. So all people should be equal, should appear to be equal before the court, regardless of economic status, race, religion. Doesn't matter. All people should appear equal before the court, and the court should base all of its decisions objectively on the law and how the law applies. Now, in the United States, we have something called judicial federalism. Hopefully you know what federalism at this point. It's that division of power and division of sovereignty between the states and the national government. And in that same manner, we have a dual court system. You have the federal courts, with the U.S. Supreme Court and the lower federal district courts and the lower federal appellate courts. And then you have 50 different state court systems. And most all of those state court systems have their own state Supreme Court, state appellate courts, and state district courts, and then even lower level courts. But when it comes to precedent and it comes to stare decisis, the U.S. Supreme Court and federal law are superior to state law. So if there's a contradiction in a state law and a federal law, and the federal law is deemed constitutional, then the federal law trumps the state law. Now let's take a look at the state court structure for the state of Texas. The courts consist of trial and appellate courts. Trial courts are the courts where the actual trial takes place. You have a judge, you have a jury, you have lawyers, you have witnesses. Okay, that's a trial court. An appellate court is a court that basically reviews the trial court transcript to ensure that everything is done properly, to ensure that all the proper procedures were followed. They generally don't hear any new evidence or hear any new witnesses. They just simply review how the judge and the lawyers and everybody handled themselves in the trial case. So an appellate court is basically when you appeal your conviction or you appeal a decision of the court to a higher court. Now, the different kinds of courts we have. First of all, we have magistrate and minor courts. They hear misdemeanors, traffic, and other minor cases. Generally, they're justice of the peace or local municipal courts, city courts, and they are, and oftentimes they are not courts of record, meaning there's not a transcript of these courts. Now, county courts, there are different types of county courts. There are constitutional county courts and county courts at law. They hear intermediate criminal and civil cases, a little tougher stuff than just parking tickets and speeding tickets. Things like DWIs, hot checks, minor drug offenses, and also the county courts may serve as the appellate court in trial de novo cases. Trial de novo are appeals of cases where the court where the trial was heard is not a court of record. As I mentioned before, justice of the peace in Texas and municipal courts in rural areas especially, they don't keep records of the minor court cases, but you can still appeal those based on trial de novo to the county courts. Next up is the district courts. These are where most of the major crimes are heard. Things like murder, arson, theft, rape, kidnapping, major criminal cases are heard in the district courts, and there are 456 of them. Also, civil cases are heard here. Okay, civil cases, so lawsuits. If you sue somebody or an entity like a corporation, you may go and have that heard in a state district court. And as I said, there are 456 state district courts. Now, once you've had your trial in the district court, and if you do not like the outcome, you may appeal that case to an appellate court. And there are 14 different appellate courts that hear cases brought up from the 456 district courts. And all criminal and civil appeals, except death penalty appeals, are heard by the 14 different appellate courts. Okay, and the appellate courts generally have multiple judges on each of them. And by the way, all of these are elected. These judges are elected. Now, once you get to past the appellate courts, which are kind of the mid appellates, they hear cases directly from the district courts. If you still are not satisfied, you may, though you may not get it heard by the courts, you may appeal one more time to the state Supreme Courts. And the state Supreme Courts, I say that plurally because there are two state Supreme Courts. We have what's called a bifurcated court system at the top, where there are two separate but equal Supreme Courts. One is called the Court of Criminal Appeals, and it is the final state court for criminal cases. All criminal cases that come through the district courts and the appellate courts, uh, if they go further in the appellate process, they end up in the Court of Criminal Appeals. Only criminal cases in the Court of Criminal Appeals. In the Texas Supreme Court, it's the final state court for civil cases and juvenile cases. Okay, so lawsuits go before the Texas Supreme Court if they are appealed higher than the district courts, higher than the appellate courts. Civil cases, meaning non-criminal cases, lawsuits and things like that. Divorces are civil cases. Also juvenile cases, anything dealing with a juvenile, if it is appealed through the entire process, ends up in the Texas Supreme Court. Here's just a little flow chart showing from bottom to top the levels of courts in the state of Texas. It's kind of complicated. It's not as clear and succinct as the federal system, but at the bottom, the lowest level, the fifth, level 5, you have the local trial courts of limited jurisdiction, the municipal courts, and the justice of the peace. You know, small claims civil courts, minor traffic offenses and parking tickets and things like that. At number 4, at the next level, you have county trial courts of limited jurisdiction, constitutional county courts that hear civil and criminal cases, county courts at law, and then statutory probate courts, with which probate wills and things like that. Then, number 3, you have state district courts. This is where the major crimes are heard. Okay, trial courts of general civil and criminal jurisdiction. So they hear, divorces, they hear lawsuits, and they also have criminal trials if somebody's charged with murder or theft or dealing drugs or whatever. And then from the district courts, if you disagree with the ruling, you may appeal, although your appeal may not be heard. You may appeal to a higher court, the state intermediate appellate courts, the Court of Appeals, and there are 14 of those. And then the final appeal in the state of Texas would be to the state Supreme Court if it's a civil case or a juvenile case, or the Court of Criminal Appeals if it is a criminal case. Now, once you get there, if you still feel like that there's some kind of civil liberties issue, civil rights issue may be involved in this case, you may, if you're not satisfied with the state Supreme Court or state Court of Criminal Appeals, you may, at that point, appeal to the U.S. Supreme Court. Okay, let's spend a little time discussing the judicial selection process in Texas and in other places. In Texas, most judges in Texas are selected in what's called partisan elections, meaning the judges run under the banner of a political party, Republican or Democrat. Of course, this, if you think about it, it's contradictory to the idea of objectivity. When one of those principles of judicial conduct is you must appear objective, it's difficult to do when you are running under the banner of a preferred political party who, by definition, has their own agenda and wants things a certain way, and maybe does not favor or care for members of other parties. So partisan elections, in my personal opinion, they're the worst way to select judges, but we'll discuss that maybe a little bit later. There are other options used in other states. As I said, partisan elections are used in 7 states, including Texas. Nonpartisan elections are used in 15 states. Now that just means the judges are elected just like they are in Texas, only they're not allowed to run with a political party next to their name, and they cannot campaign as a member of a political party when running for the office. More states are using different types, like the Missouri plan. The Missouri plan is a combination of appointment and election. According to Missouri plan, you have a commission that is put together of a commission of nonpartisan people who have knowledge of the legal system, knowledge of the court system, knowledge of lawyers. And this commission suggests or culls through the candidates for the judgeship, and they will choose, 5 or 6 candidates, and then they will send these, and hopefully these will weed out the unqualified candidates. That's the whole point. And it will send these candidates to the governor, and the governor will choose one of these candidates to serve as judge for a certain length of time, for a term, be it 4 years or 6 years. And then when that term is up, the judges then stand for a retention election, meaning that then the electoral process becomes part of the process. And then they stand for election. So initially they are vetted and they are appointed by this commission and by the governor. And then after that, the people get to decide whether they will be retained or not. And then finally, you have the true appointment of a judge, where the governor appoints the judge, and then usually it has to be ratified or approved by either one or both houses of the state legislature. The problems with partisan elections in Texas, the idea that judges run as Republicans or Democrats, is that oftentimes voting is based on name familiarity. Okay, you see a name you've heard of, and you vote for it, or you vote based on the political party without any knowledge of how qualified the candidate may be. Also, straight ticket voting. Straight ticket voting is the process of just, when you go to vote, you just choose all Democrats or all Republicans, and there's a place where you can do that. Well, by doing that, you are not really voting for anybody. You're just voting for that political party. And just because somebody puts an R for Republican or a D for Democrat next to their name does not mean that they are qualified. Campaign contributions. One of the bigger problems with partisan elections of judges especially is that it requires a lot of money to campaign, especially the appellate and the Supreme Court, because that's a statewide election. And so you have to raise money. It's expensive to advertise. And when you raise money from campaign donors, those campaign donors expect something in return. They may not come out and say it, but if you give money to somebody for a campaign, you expect favorable rulings that you prefer as a campaign donor, as a campaign contributor. And so the judges know this. The judges know that somebody gave them, $100,000 for their election, and that they probably want them to rule a certain way in a certain case. And then, of course, it's difficult to get minority representation, especially statewide offices, in these elections. And then there's electorate pressure. Oftentimes the correct judicial decision is not a popular decision amongst the electorate. Letting somebody who the public thinks is a guilty, heinous criminal go free because legally that's what you're supposed to do, that can cost you your job. That can cost you an election. Even though you're doing your job correctly and you're making the proper judicial decision, it could be unpopular. And so oftentimes maybe judges feel pressure to not make the correct ruling, but make the popular ruling, and which may not be the correct ruling. And so all these different problems arise when you have partisan elections of judges. So which of these systems is best? Well, they all have, their good points, I think, except maybe true partisan elections. But I like the Missouri plan myself. The fact that, people who are knowledgeable of the legal profession and knowledgeable of lawyers and judges choose qualified candidates. And then you still have the process of giving the governor the option of appointing one of those people. Now, how to remove a judge in Texas? Impeachment, same process for the governor. You get impeached in the House of Representatives, which is by a decision of a majority of the House. There's enough evidence to put the judge on trial, and then they have the trial in the state Senate. The Texas Supreme Court may also remove any judge. So if a judge is not acting appropriately, ruling appropriately, the Texas Supreme Court may remove a judge. A district judge may remove county judges and justice of the peace. So, you can remove lower level judges. State Commission on Judicial Conduct may recommend the removal of any judge, including the Supreme Court justices. Now, as far as the legal system goes, in Texas, we have what's called grand juries. And these are juries of citizens that determine if a person will be charged with a crime. And they're kind of a buffer between the prosecution and the police and the citizen. And hopefully the goal is to prevent unscrupulous prosecutors or unscrupulous police from going after somebody unfairly and trying to railroad them into an arrest and a conviction. So basically it's a 12-member jury that sits for, it could be anywhere from a month to 6 months, and it's chosen by the district judges. And they serve, 6-month terms usually. And what they do is they will be presented evidence by the district attorney or the district attorney's office, and they will say, okay, here's the evidence we have against this person, and we believe it's enough evidence to charge them with a crime. And then the grand jury makes the decision as to whether they will be charged with a crime or not. Now, in lieu of this, meaning if not all are done by a grand jury, you could have an information or administrative hearing, which is a hearing before a judge who decides if a person must stand trial. And it can be used in place of a grand jury. And in order to expedite some cases, that's what they will do. They will have an administrative hearing. Texas uses both grand juries and administrative hearings. Now, the jury probably we're most familiar with is called a petty jury. It's spelled P-E-T-I-T, but it's pronounced like P-E-T-T-Y, petty jury. And this is a jury of citizens that determine the guilt or innocence of a person during a trial. It's the one where you see on TV, people sit and listen to the lawyers and listen to the judge and the prosecutors, and then make the final decision to determine guilt or innocence. But here's the funny thing. These are the kind of trials we see all over the television. But nationwide, only about 5% of all criminal cases end up in a jury trial. Most all of them end up in what's called plea bargains, where the prosecutor and the defense attorney will negotiate a lower sentence for a guilty plea. They might plead guilty to the case for a lesser sentence, and it prevents a lengthy trial. It prevents the clogging up of the judicial system. But oftentimes, the only people that can really afford a true trial, jury trial, are people that have economic means. Most poor people end up needing to plead out because they can't afford the necessary legal help. And also, if you do go on trial, your eventual sentence for your crime will oftentimes be much more than, if you're convicted, be much more than if you pled out. In conclusion, all information in this presentation, as well as all information in the chapter, may appear on the exams.